Madam Chair, committee members, and participants, we are now live.
I understand that state law currently requires that the following announcement be made at the beginning of every remote public hearing as follows. Due to the current public health emergency, City Council committees are currently meeting remotely. We are using Microsoft Teams to make these remote hearings possible. Instructions for how the public may view and offer public testimony at public hearings of council committees are included in the public hearing notices that are published in the Daily News, Inquirer, and Legal Intelligencer prior to the hearings, and can also be found on phlcouncil.com. I now note that the hour has come. Sydney Sherrills, will you please call the roll to take attendance? Members that are in attendance will please indicate that you are present when your name is called. Also, please say a few brief words when responding so that your image will be displayed on screen when you speak.
Vice Chair Jones. Councilmember Gilmore Richardson.
Good morning, Madam Chair. Good morning, colleagues. I am present.
Good morning.
Councilmember Bass.
Good morning, everyone. I am present.
Councilmember Squilla.
Good morning, Madam Chair and colleagues. I'm present.
Councilmember
Good
Brooks.
morning.
Good morning. I'm present.
Councilmember Driscoll.
Councilmember Driscoll, are you there? Thank you. A quorum of the committee has been established and this hearing is now called to order. This is the public hearing of the Committee on Housing, Neighborhood Development, and the Homeless regarding resolution number 200433. Ms. Sherrills, will you please read the title of the resolution?
Resolution number 200433, authorizing the City Council Committee on Housing, Neighborhood Development, and the Homeless to hold hearings on the role and responsibilities of Philadelphia's landlord-tenant officer position, the policies and procedures it manages in the eviction process, particularly around writs of service, and clarifying oversight, ethics, and public accountability for the landlord-tenant office.
Before we begin to hear testimony from the witnesses we have for today, everyone who has been invited to the meeting to testify should be aware that this public hearing is being recorded. Because the hearing is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in the meeting, you are consenting to being recorded. Additionally, prior to recognizing members for the questions or comments they have for witnesses, I will note for the record at this time that we will use the chat feature available in Microsoft Teams to allow members to signify that they wish to be recognized. In order to comply with the Sunshine Act, the chat feature must only be used for this purpose. And I want to acknowledge the presence of Councilmember Driscoll. Good morning. Before we begin, I'd like to make a few remarks about the legislation before this committee today. We are gathered here this morning to shine some light on the landlord-tenant officer, a private, unelected individual turning a profit by catapulting residents out of their homes. Philadelphia is the only city in the Commonwealth that empowers a private citizen to execute evictions. And because the landlord-tenant officer pockets the profit each time a resident is evicted by one of her deputies, she is incentivized to keep prices lower and serve writs faster than the sheriff's office. So it's no wonder an overwhelming majority of landlords use the landlord-tenant officer's services. There is no written contract between the municipal court and the landlord-tenant officer. There is no public bidding process, no standard for how to execute evictions, no mandatory training or law enforcement certification for deputies, and no accountability and oversight. Evictions conducted by the landlord-tenant officer and her deputies follow a harmful formula that traumatizes neighbors without life-saving resources when they need them the most. Here's how evictions are typically executed here in the city of brotherly love and sisterly affection. A contractor armed with a gun shows up at the tenant's door without a uniform and without warning. The contractor commands the tenant to grab whatever they can within 10 minutes before they are locked out of their homes forever. Families desperately run around grabbing medication, identification, and other essentials. If they have time, they feed their pets and call their loved ones to figure out where they will sleep that night. After 10 minutes, the armed contractor and landlord change the locks and depart without giving the family a single resource or telling them where they can go for help. The contractor moves on because time is money, and the more evictions they complete that day, the more they profit. When I first heard a constituent recount this process, it left me thunderstruck. And while there are many flaws with how the landlord-tenant officer executes evictions, the one that gives me the most pause is that unlike other cities, the families become evicted without warning. This means evictions almost always happen many months after the last communication between the court and a tenant. So when the deputy landlord-tenant officer knocks on their door, they are completely caught off guard. Similarly, we have no guidelines in place that institute a standardized eviction procedure or policies requiring deputy landlord-tenant officers to complete firearm safety training, de-escalation training, harm reduction training, or any sort of common sense law enforcement certifications our first responders participate in. And it was in this context that an armed security contractor showed up at Angel Davis's door shortly after 9 a.m. on Wednesday, March 29th. Angel had spent months in court with her landlord over major repair issues and unpaid rent. Her mother told us Angel requested an extension on her eviction and was not expecting to be locked out. And Angel's live-in partner remarked that they had no idea what was going on when the armed contractor showed up unannounced that terrible morning. Confusion ensued, and a few minutes later, the deputy landlord-tenant officer shot Angel Davis in the head in her own home. After days in critical condition, Angel Davis thankfully survived, but she continues to suffer from serious traumatic brain injuries and is not healthy enough to be with us here today. City Council has an obligation to examine the cause of this inexcusable tragedy and to make sure that it never happens again. That is why Councilmember Brooks and I have spent the last few months taking a deep dive into how Philadelphia conducts evictions. What we have found is a violent, traumatic, and dangerous system that demands reform. Because structural issues with the landlord-tenant officer began long before the shooting of Angel Davis. In fact, the resolution to authorize this hearing was passed by City Council 3 years ago, after we heard widespread concern about the behavior of the landlord-tenant office. Regrettably, the pandemic delayed the hearing. And before Councilmember Brooks and I even took office, Mayor Kenny's task force on eviction prevention and response critiqued the landlord-tenant officer's refusal to notify tenants about their eviction ahead of time and called for reform. Simply put, all of us, the city council, and the court have been complicit in allowing this deeply flawed and deeply harmful institution to operate for far too long. It is past time that we show our residents that we are listening by substantially reforming how we execute evictions. I applaud President Judge Dugan and Judge Wolf for beginning an internal process to reform the landlord-tenant officer. City Council and the court worked hand in hand to create the nationally acclaimed eviction diversion program, which continues to keep thousands of residents in their homes. I look forward to expanding our partnership to include transforming how we execute evictions in our city. And I hope this hearing proves to the public that City Council is committed to seeing meaningful take place. We will not allow economically violent evictions to turn physically violent again. I see Councilmember Brooks would like to make some opening comments as well.
Thank you so much, Chair Gautier, for hosting this meeting. The forced removal of a person from their home is an area of grave public concern that we have a lifelong impact on tenants, their children, and communities. If an eviction must take place, it must be done in a manner that is safe, well-regulated, and accountable to public, transparent, and integrated it with the delivery of city services. Before we delve into what reforms are needed, I want to address the big underlying question as we discuss lockouts and why doesn't everyone leave before the locks are changed. There are two main reasons for this question. First, for many, the answer is that they do not even know that the court has ordered their eviction. We will hear today about tenants who are paying their rent and thought they were current, who believed they were on a payment plan, and who thought their eviction was postponed when a private security officer certainly shows up to their home and forces them out. The only notice Angel Davis might have received that she was going to be evicted after 5 months of a court battle was a simple letter in the mail, if she received that at all. These are not tragic outliers. This is a systemic problem. The mayor's eviction task force found that half of the illegal evictions in Philly were a result of default judgments, which happen when tenants are not present for a hearing. This bears repeating. Half of all evictions in Philadelphia are by default. A report from the Scheller Center of Social Justice at Temple University School of Law analyzed 430 petitions from Philadelphia tenants who lost their cases because they missed their hearing. 1 in 5 cite the fact they hadn't received a notice for the hearing. The second reason is that folks do not leave their homes before the lockout. Is that they're simply nowhere to go. While it had once been known for low-income renters to find another apartment a month or two, this is no longer the case. Rents in our city have skyrocketed, and paychecks and Section 8 have not caught up yet. There are simply not enough beds in the shelters for those who need them. And this crisis is even more pronounced for many of the folks we're going to hear from today. Those with disabilities, those with medical needs, and the elderly need to be able to go to a place that meets their basic needs. If we want to ensure that what happened to Angel Davis never happens again, if we want to address the dangerous, traumatic, and deeply harmful way that evictions are conducted in the city, there are a few standards we must meet. If an eviction must take place, it must be done in a way that is 1, safe, 2, well-regulated and accountable to the public, 3, transparent, and 4, integrated with the city's delivery of services. The first one, evictions must be safe. Tenants and their attorneys, healthcare aides, and social service workers need to know when they will be locked out of their apartments. As we will hear, tenants in other cities in Pennsylvania, across Pennsylvania, and across the country know what day, even what time their eviction will take place. And Philadelphians deserve the same. Extensive and frequent training is another basic requirement for a safe eviction. In the rest of the Commonwealth, constables who conduct evictions receive 80 hours of training, including on use of force and firearms before they conduct evictions. In Pittsburgh, for example, those who do evictions need certification for firearms and annual training. In Philadelphia, there's no requirement for the landlord-tenant officer or any contractors they hire to undergo training of any kind. There is no specific training on the use of force or certification for the use of firearms. Second, any eviction system must be accountable to the public and well-regulated. The landlord-tenant officer and their contractors act under the authority of the government and receive millions of dollars in payments for conducting the grave public act of removing someone from their home. And yet there is no written contract governing their actions. There's no standards of how they will conduct their eviction, and there's no defined method to hold a landlord-tenant officer or their contractors accountable to the public. There is no fixed budget or salary for landlord-tenant officer, and so the private entity has a financial incentive to conduct as many evictions as possible and as quickly as possible. In Philadelphia, a single landlord-tenant officer conducts all evictions that are not done through the sheriff's office. In localities across the country, including Pittsburgh and New York, there are several options of organizations that conduct evictions, all under an umbrella of numerous regulations and standards. Having multiple options is what makes people accountable. Third, an eviction process must be transparent to all. New York City has a 236-page manual for those who do evictions. Allegheny County has a 77-page manual. Philadelphia does not have any written guidelines. Cities like New York City and Pittsburgh have many rules and regulations specifically concerning situations where the tenants have disabilities, medical needs, or children. This allows tenants, their advocates, healthcare workers, and families to know and plan for an eviction. Last, the eviction process must be integrated with the city's delivery of services. Evictions are violent, traumatic, and destructive for tenants, for their children, and for the communities. If people are going to be forced from their home under the power of the government, we must also connect them to services that our city provides for them. As we will hear, in New York City, social workers are informed of evictions of those with needs in advance, and the social workers are there when the eviction takes place. In Philadelphia, a social worker should accompany those who do the lockouts so we can ensure that families are connected to all the resources that are available to them in the moment, especially at a moment of great need. I want to commend President Judge Dugan and Judge Wolf for starting a process to reform the landlord-tenant office. I look forward to working with the court to create a program that becomes a national model, just as we did with the eviction program that saves the homes of thousands of Philadelphians each year. I want to thank the tenants, the advocates, and Angel Davis and her family who have all done so much to push for reform. I want to thank all the testifiers today, and I know how devastatingly hard it is to share personal stories about losing a home. And we also appreciate the trust of Xavier Carthen and Mark Preston to share their words about this experience, like what this experience was like. Thank you so much, Chair Gauthier.
Thank you, Council Member. Are there any other members of the committee that would like to give opening remarks? Okay, with that, Ms. Sherrills, will you please call the first panel or witness we have to testify this morning?
The first panel is Xavier Carthen, Sherry Thomas, Mark Person, Seamus Brennan, and Jacob Spidell.
Xavier Carthen, are you there and connected? Do we know if we have Xavier on? Okay. Sherry Thomas, are you there and connected?
Council member, somebody will be reading Xavier's testimony on his behalf.
Okay, is that person ready?
Yes, it's Nora Casper.
Hi.
Okay. Hi, Nora. Thank you so much for being here. Can you please state your name for the record and proceed with Xavier's testimony?
Yes, so my name is Nora Casper. I am a law student and summer intern with the AIDS Law Project of Pennsylvania. I'm going to be reading Xavier Carthen's testimony. He's a client of AIDS Law Project who is unable to attend today. And a written copy of the testimony has been circulated to members of the committee and so I will begin reading. This February, I was locked out of my apartment in Philadelphia, where I had been living for 4 years and 8 months. I was at home on a Monday morning when there was a banging on my apartment door. When I answered, a large man was there with the building manager. He was an officer serving me with eviction papers who frightened me as he yelled out loud, "You are being evicted. Here's a copy of the order, and you got 10 minutes to gather some things and get out, and you have 30 days to get all of your things out of here, but you must leave now." I did not understand why this was happening. I had been working with my property manager to get caught up on my rent and did not have any warning that this was coming. Because I was completely unprepared for this situation, I was in a state of shock filled with so much confusion. I immediately started trying to put out food and fresh litter for my cats. I did not know this was coming and was worried they would be locked inside for a long time. I had no time to gather my belongings and just grabbed what I could. I felt a constant pressure to move quickly. While the officer did not touch me, he did come very close to me and constantly reminded me that I only had a few minutes left. After they changed my locks, I waited for my friend to drive back from the Northeast to help me because I had nowhere to go. I have been living in my friend's basement since then, trying to get myself organized and ready to find a new place, and it has been hard finding a new place with my fixed income unless I rent a room in one of these illegal houses. That same day, I contacted a lawyer and they explained what had happened. I had been to court in January 2022 and made a payment plan with the landlord's lawyer. Apparently, I was given a notice in March 2022 that I was being locked out, but I was still paying my rent and there did not seem to be an issue with the landlord until December. I thought the old payment plan was done and I was trying to work it out with the landlord. If I had known they were going to lock me out, I could have been better prepared to fix this matter with them or find another apartment. Thank you.
Thank you so much for the testimony, and please share our gratitude with Xavier for sharing their story with us. Sherry Thomas, are you there and connected?
Yes, I'm here.
Please state your name for the record and proceed with your testimony.
Sherry Thomas with the Legal Clinic for the Disabled. Thank you for the opportunity to submit testimony today regarding resolution number 200433. I submit this testimony in my capacity as the Director of Housing at the Legal Clinic for the Disabled, otherwise known as LCD. LCD is a direct legal services agency serving low-income individuals living with physical and mental health disabilities and is a partner in the Philadelphia Eviction Prevention Project. If you could imagine with me for a minute the last time you moved homes, think of everything you needed to do to make the move go smoothly. You likely spent significant time packing your things over the course of days or weeks. You may have hired movers. You may have enlisted friends or family to help and rented a truck. Even with ample time, resources, and predictability, moving is a stressful event. Now imagine doing all of those things while also managing the fragile medical health of yourself, a spouse, or a child, not knowing the day or time that the move will happen, and not knowing who will be coming to your door. For a significant number of renters in Philadelphia, this is not a fictional scenario, but one which they have experienced. Forcible removal from one's home is a distressing event for anyone, but for someone living with a disability, the challenges multiply. Someone with a disability may have durable medical equipment, such as a wheelchair, a walker, or a commode that must be transported with them. They may be confined to a hospital bed, which requires extra care when moving out of a property. Taking multiple prescription medications is the norm if you live with a chronic condition, and those medications are necessary and must come with you if you are moving. If you are not living with a disability, you might not think about these things. But from our experience with the landlord-tenant office, it is not transparent or predictable what the office's policies or procedures are when handling a tenant with a disability. This lack of transparency and predictability from the landlord-tenant office is acutely felt by those with disabilities. So little information is shared by the landlord-tenant office on how they do business. So what I share today is information gathered from our clients who have experienced eviction firsthand, as well as what LCD attorneys have seen from our own interactions with the landlord-tenant office. This lack of transparency and predictability is most glaring with the internal policy that the office will not share the date or time a lockout is scheduled, despite the medical needs or special circumstances of the tenant. On multiple occasions, we have presented fact-specific circumstances to the landlord-tenant office to get a date or time for the lockout so we may prepare our clients to leave the property with everything they need. For someone with a disability, leaving the property does not just mean physically removing themselves and their equipment, but it also means arranging a safe way for that equipment to be transported or stored once they are out of the property. We take for granted that someone will be able to physically carry whatever they need on their person when they are evicted. I represented a tenant who was locked out of her property without medical equipment. She had double knee replacements and was getting around her home very slowly with the assistance of a walker and an assistive rolling chair. She had 2 cats. One morning, after she had just woken up and while still in her pajamas, she heard loud banging at her door. When she answered, she was confronted by the landlord-tenant officer, who told her she was being evicted and that she had 10 minutes to get her things. She had no idea what was going on. It turns out that her landlord got a default judgment against her without her knowing. He told her she did not need to attend her hearing because he would be withdrawing her case. Instead, he took a default judgment and continued to collect rent from her while he scheduled a lockout. She did not receive any writs until the day the officer showed up at her door, and she did not know there would be a lockout. She had no choice but to leave with the clothes on her back. She did not have time to gather her equipment, and she was aided out of the home by nearby neighbors who had seen everything unfold from their porch. Her cats were put out, and she still does not know what happened to them. That day was the last day that she saw her pets. Thankfully, she had someone who was able to drive her to a hotel. For weeks, she stayed at an extended stay hotel without her walker and chair because the landlord then refused access without additional payments. It was only after she got a lawyer that she was able to return to the property. Last fall, LCD had a senior citizen client who was incredibly medically fragile. LCD attempted to connect the tenant to social services. However, one of the first questions we were asked was the date or time that the lockout would occur. Despite requests to both the landlord and the landlord-tenant office, this information was not shared with us. The tenant stayed in limbo and in fear, not able to leave on his own because of how fragile he was, but also not knowing when he would be put out on the street. He did not have good shelter options due to his health, and he was vulnerable to scam landlords in his desperation to leave the property before an officer showed up. Last week, I received a call from a tenant inquiring about when her eviction might be. She has an autistic child, and she wants to make sure that she is out of the property before an officer comes to her door and compromises her child's health. Under the landlord-tenant office's current policy, she will not be able to get this information. Another LCD client left the property in such a hurry that she did not have all of her prescription medications. By the way, most tenants who have shared their experiences with us have expressed they get approximately 10 to 15 minutes to vacate the property with everything they need. Personally, I was with a tenant one day when the landlord-tenant officer arrived to her home. I was present with her as she frantically spoke with her husband and children over the phone. She was with me and they were at home. While their locks were being changed, I could hear everything that was happening. I can attest that the entire process took about 10 minutes as well. These illustrative examples are of people who are home or expect to be home when the landlord-tenant officer arrives. This does not account for people who are not in the home when a lockout occurs. For them, it is impossible to have what they need unless they are carrying all of their equipment, devices, and medication on their person. Someone who needed to leave the home for a medical appointment, grocery shopping, or any number of daily activities are then at the mercy of their landlord's schedule and discretion to gain access again to the home. A simple change in this one policy would increase transparency and predictability, reducing harm to many Philadelphians. It may not be possible to entirely eliminate the harm that comes from the traumatic process of eviction, as it is an inherently violent process to forcibly remove someone from their home. However, there are several ways for the landlord-tenant office or another entity to practice harm reduction, only one of which was highlighted above. Transparency, predictability, and accountability through written policies, procedures, consistent and frequent training is possible. Ultimately, this call for transparency, accountability, and regulation is to ensure people are still treated with dignity and respect for their humanity, especially when they experience one of the most distressing events of their lives. Thank you.
Thank you so much for your testimony and for your work. Mark Person, are you there and connected?
Yes.
Are you connected on more than one device? That might be the reason for the echo.
Yes. Good morning, Ms. Cartier and Ms. Brooks.
Good morning.
Right. My name is Mark Person, and I was evicted of February this year. We had fell out due to a lease agreement that was to my advantage, and my landlord moved to evict me. I reached an agreement with my landlord to make payments and to get extermination done in the property. There was a really bad infestation after the apartment flooded from poor maintenance. My landlord scheduled an extermination and did not give me notice. I'm a senior citizen with disabilities and needed time to prepare for the extermination. The home wasn't fully prepared for extermination because of that. Based on me supposedly not being prepared, my landlord decided to move forward with the eviction and was given permission by the court to do that. The whole time I thought we were going to work something out, but instead I was evicted. That was on February 6th, and I was locked out on February the 14th. The day of the lockout, I received a message from a neighbor that the sheriff was coming. She told me they were knocking on doors, and 10 minutes later, I got a knock on the door. The big guy said he was a sheriff and I had to leave the premises. He never showed ID, just came in and said, "What about?" And I said, "What about my stuff?" And he said, "Get what you need and go." I was not dressed at the time, nor aware they were coming or receiving notice other than from my neighbor that day. As I was trying to figure out what to take, he looked at his watch and said I had 10 minutes and that he had others to serve and that I had to hurry up and be out. There was no notice or courtesy, just him standing with his hand atop his pistol like a cowboy western. He seemed to become agitated when I asked where am I to go. Then a guy came and started changing the locks. He never gave me a time frame after that. He just said I had to hurry up and get some things and get out because he had 2 other people to serve. So I put on my clothes and grabbed some papers, and me and my son left with my cat, wondering what our next move was. I'm a senior. I have bad knees and a bad shoulder. I can't move around that easily, and he was telling me to get my things and go, but I was flustered and stressed and really just had no time to prepare. I didn't know what to take with me. I had to rush out of there, and I had to get rid of my cat, and that was the last day I saw him. Basically, that's what happened, and I'd like to thank you for giving me a chance to share this with you.
Thank you for sharing your story with us. I'm really sorry that happened. I'm sorry that you were separated from your pet, and we appreciate you coming and sharing your story for the benefit of others.
Thank you.
Seamus Brennan, are you there and connected?
Good morning.
Good morning.
Hi.
Please.
My name is Seamus Brennan. I'm a staff attorney at the AIDS Law Project of Pennsylvania. Thank you for this opportunity to share the experiences of some of my clients and the interactions that they've had with the landlord-tenant officer system. These stories will highlight how tenants are not given useful information, and often the information they are given is wrong. Because tenants do not know what the landlord-tenant officer is going to do, they do not have any meaningful opportunity to assert their rights or to plan for an orderly lockout. One of my clients was being evicted from the home where he lived with his family, and after the matter was resolved in court, the landlord-tenant officer scheduled a lockout. This lockout was scheduled 2 weeks earlier than was permitted by the terms of the settlement agreement, the judgment by agreement, that he had reached with his landlord. I reached out to the landlord-tenant officer, who claimed that the court had instructed her, quote, that said eviction can go ahead, unquote, and only through the intervention of the plaintiff's attorney were we able to have the landlord-tenant officer follow the terms of the judgment by agreement. Unfortunately, because of the secrecy surrounding the office, there's no way to know what instruction the court actually provided in this case, or why the landlord-tenant officer had scheduled a lockout that would violate the terms of the settlement agreement. This kind of error is not unusual, and it was only identified because an attorney checked the list of lockouts scheduled for the following week. That list, which is shared with the managing director's office, is the main window we have into what the office is planning to do, and it's not widely advertised or widely shared. Tenants who do not have attorneys do not even have the minimal warning that it provides. There is a document that is supposed to give that warning, and it's called the writ of possession. These writs are often inaccurate. Every writ of possession I have seen served by a landlord-tenant officer includes the language, quote, you are hereby notified to vacate the premises, and then it lists the address, within 11 days of this written notice, i.e. no later than a date that is filled in by hand, end quote. It's important to understand that the 11 days and the date are handwritten. The writs of possession are served by the landlord-tenant officer mechanically. They always list 11 days, even when the judgment or the judgment by agreement specify a different lockout date. This is particularly a problem where tenants have agreed to a payment plan or other agreement that gives them the possibility of an open-ended tenancy, where there's not a guarantee that this is going to end in a lockout. Because the landlord-tenant officers are providing inaccurate information on the writs of possession, they're creating needless fear and unjustifiable confusion for tenants. This lack of notice is particularly harmful to tenants who need assistance or live with disabilities. I remember one of my clients was being evicted because of a conditions issue in her apartment, and she was struggling to pack because she was an amputee and did not have properly fitted prostheses. She was, on the one hand, searching for accessible housing that would accept her voucher, and on the other, I was begging for more time from the landlord's attorney. Ultimately, a team of us, of lawyers and social workers, were supporting her in this move, but we were not told of the scheduled eviction until the day of the lockout. On that day, the average outside temperature was 32 degrees. My client spent the next few days shuffling from agency to agency, often being required to wait outside of shelters while they tried to find a long-term placement that could accommodate her medical needs. A year and a half later, she still lacks permanent housing and is living in shelter. My client and her supports were only given 24 hours notice of the lockout. And if she had had even a few days more warning, she would not have had to have those waits in the cold. The process of physically evicting someone is inherently violent, even if no one is injured. And because we do these actions as a society, because we take these actions as a society through our courts, it is a form of official violence. And it really should be limited, accountable, and transparent. The current system is not any of those things, but it doesn't have to be that way. My practice does extend a bit beyond Philadelphia, and there are better ways. If we had a public and accountable method for executing judgments, we could demand clear standards for notice, for accommodating the needs of vulnerable people, or simply defining what weather is too severe to leave someone on the street. What we have heard in discussing alternatives is that there is no option of going to the sheriff's office, that they couldn't possibly handle it. I don't know if they are the answer, but I have seen them serve writs of possession. Last summer, one of my clients was served by the sheriff's department. He was taken by surprise because the claim that had been filed against him was not in the name of the landlord that he knew. It was in the name of a company he'd never heard of. The deputy handled this situation very professionally, took the time to explain to my client that if he had questions about the writ, he could contact the court. That interaction made a lasting impression on my client. He remembers that deputy's name. He knows who served him and who took the time to explain what was happening. It may be that landlord-tenant officers do the same thing, but I've never heard about it from a tenant. And I can't help but think that the difference is between the structures of the office, where one is motivated by moving quickly and earning a profit, and the other is performing a public function. In Upper Darby, I had a client who was served with a lockout notice by a constable. Unfortunately, my client was out of town at the time, but the deputy called him, found his phone number, and made the call to make arrangements for a pet that was in the home. Again, I've never heard of a landlord-tenant officer calling a tenant during a lockout. Clearly, there are humane ways to handle these situations, but we can't trust that they will happen in a culture of profit and secrecy. Thank you for the time of the committee.
Thank you so much for your testimony and for making those important comparisons between the landlord-tenant office and the sheriff's office. Jacob Spidell, are you there and connected?
Yes, this is Jacob Spidell.
Thank you. Please state your name for the record and proceed with your testimony.
Thank you, council members, for this opportunity to speak. My name is Jacob Spidell, and I am the Director of Tenant Rights at Senior Law Center. At Senior Law Center, we seek justice for older adults by using the power of the law, educating the community, and advocating on local, state, and national levels. We're the only nonprofit organization in Pennsylvania whose mission is dedicated solely to providing legal services to older persons. In our work, we assist older people facing evictions and other threats to safe shelter. We also represent low-income older landlords trying to evict tenants who have abused them. We appreciate the council taking the time to consider how the city's process for locking out tenants during an eviction is working and how it can be improved to better serve tenants, landlords, and the community. And I really echo the priorities mentioned by Councilmember Brooks, that evictions must be safe, accountable, and well regulated, transparent, and integrated with the delivery of services. As an example of what older tenants in Philadelphia are facing, we recently spoke to an older tenant who was locked out without his medications. After the lockout, he asked the landlord to let him back into the property to get his medications, and the landlord didn't respond. This was causing a significant danger to his health. The landlord-tenant officer should have a policy requiring tenants to be allowed sufficient time to gather their medications at the time of a lockout. We also often get calls from tenants who have been locked out and did not have adequate notice. And this may sound familiar. What I will describe is a different tenant from any tenant you've heard previously, but it's a similar problem. So we recently spoke to a tenant who came home one day and had been locked out unexpectedly. It turns out that back in February of 2022, this tenant had signed a judgment with an agreement for a payment plan. The tenant didn't have a lawyer, and the court judgment said the tenant could stay in the property as long as they made payments. On March 23rd of 2022, that tenant was served with the writ of possession, saying the tenant had to be out in 11 days. These writs of possession are regularly served on tenants who do not actually have to move out because they are making payments as agreed under a payment plan. Her landlord told her to ignore the writ because she was making the payments. Then, over a year later, in April of 2023, the tenant came home and had been locked out with no further warning or service of a writ of possession. The tenant didn't have a lawyer, so there was no lawyer to check the very limited list that at least some attorneys have access to. The time she was locked out in April 2023, again, the last notice she had received of a pending lockout was over a year earlier in March of 2022, and said that a lockout would occur in 11 days. This is why writs should become stale after a defined time. A landlord should not be able to serve a writ and then sit indefinitely and then schedule a lockout over a year later because they have decided that they now want the tenant out. Now, supposedly this tenant had been mailed an affidavit of breach last October, 6 months before the lockout, but she did not receive that. Senior Law Center also represented a bed-bound older tenant who had limited support from family and friends and little access to technology. She had a home health aide who delivered a money order from her to her landlord every month to pay her rent. Then, several months in a row, the aide stole the money order. The landlord filed an eviction case. We were able to negotiate an agreement where the tenant would pay ongoing rent and have half a year to get rental assistance to cover the back money from when her money was stolen by her aide. Unfortunately, she was unable to pay her rent the next month, even though she had the money to pay, because there was an issue with the electronic payment system and she couldn't leave her bed to go pay the landlord herself. The landlord filed a breach, scheduled a lockout. Our office was able to petition the court for an emergency delay of the lockout, and we were able to help the tenant with the process of making her payments and prevent the lockout. This case highlights a number of issues with the lockout process. The lack of transparency as to the day and time of the lockout means that medically vulnerable older tenants can't make plans to prevent lockouts. And if they need to move, it is harder to manage that planning. For a bedbound or disabled older tenant, managing a move on short notice requires a great deal of planning. Many older tenants have medical devices that require special handling, and they are reliant on friends or family or expensive moving companies that take time to arrange. The landlord-tenant officer should inform tenants in advance of the actual day and time of the lockout to make it more possible for them to move smoothly. And the council should require the landlord-tenant officer to have publicly available written policies, like other cities do, addressing how particular situations will be handled. We would also like to highlight that, especially in larger buildings with multiple entrances, when there is the writ of possession served saying you have to be out in 11 days, which may or may not be true, that notice is often served by posting. We have seen many cases where a notice is posted at a door that the tenant doesn't use, so they have no idea that the lockout is scheduled at all. Finally, pets are very important for many of the older tenants we serve, and we have had many cases where an older tenant was locked out and their pet was locked in the home with no food or water available for the pet. We had one case recently where a tenant was locked out. Their dog was removed to an animal shelter, and when the tenant made it to the shelter to retrieve their dog, the dog had already been killed by the shelter. Another tenant's cat was left alone in a locked up apartment for days until the tenant was able to persuade the landlord to let him back in to collect his cat. We urge the council to consider requiring rules for how pets are to be handled by the landlord-tenant officer. In addition, information about the date and time of the lockout would help tenants make arrangements for their pets. Imagine if somebody showed up at your home and said you had 10 minutes to get everything you need and to round up your pets to get them out of the home. We continue to support all the proposals that our fellow advocates have brought forward, and we hope that highlighting how the current system, especially difficult for older tenants, helps the council craft reforms. Thank you for your time.
Thank you for that important testimony and for your work. Councilmember Brooks, do you have questions for the panel?
Yes, I do. I have one specific question, and this is open to any of the panelists. In your experience, how have city services been integrated into the eviction process? And what is it like for tenants to try to access the much needed services like housing or medical resources as they go through the eviction process?
I'll start. So at LC, hold on, I'm getting an echo. Hold on one second. Okay, so at LCD, our experience has been that they're not very well integrated. We find that it's difficult to figure out which city agencies are responsible or have the resources available to our clients. I think one of the things that we run into as legal service providers is that we're legal service providers, staff of lawyers. We do, a lot of our agencies are in the process of hiring social workers and having them on staff. But as it sits right now, there isn't a lot of integration between the tenants that we see and the agencies that they should be connected to. We find that it's one of the things that's lacking is the extra help that our clients may need, to fill out paperwork, to get to places in person. There's a few agencies where you must go in person to intake, and we find that to be difficult for our clients. And, our attorneys do as much as we can and wear those different hats, but in our experience, the integration leaves a lot to be desired.
You're on mute, council member.
Thank you so much for that. Is Mr. Pearson still online?
He is. Let me just get him on for you. Hold on one second.
Hello, Mr. Pearson.
Yes, Ms. Brooks. That's person too.
Person, sorry.
It's all right.
Mr. Person, I was to the same question, like when you were experiencing this lockout eviction, what city services were available to you and who helped you kind of access or gather the support from the city as you were going through this process?
Well, pretty much the only person I had was Miss Thomas here because I wasn't allowed, I tried to find different things. I went to my daughter's, which was not much space for me. I stayed in a van that I rented with my stuff. I actually slept in there. I went to a shelter, which was a heck of an experience. But as far as help, there wasn't too much. In fact, like the owner, he seemed to have a lot of influence on a lot of things, and I ran into a lot of roadblocks. This is even now. It's been like mentally, physically, it's been very trying. And like I said, the resources that I went to, there was limited help. I even at the time the stuff was going on, I reached out to Councilman Curtis Thomas is the name, his office, and he helped me what he could, but they already had what they were going to do. It was like no help, Like I said, even my cat. I mean, it's funny. I miss him the most because he went through hell. He ran through that house and tore up, and it was. I mean, it's hard to explain. I wouldn't wish this on my worst enemy, going through this process with nobody to help, to turn to. You don't want to put that burden on family members, and you really feel alienated. Like I said, I went through a lot of mental stress, not realizing like my other injuries I had due to this. And my doctor was telling me like this is kind of normal because you don't realize like your physical things because of this. I'm just like, if it wasn't for this law office, I don't know what I would have did.
Thank you so much, Mr. Persons, for sharing your story. Councilmember Gautier, I don't have any more questions.
Thank you, council member. I have two questions. For the legal services partners on the panel, have we seen anything like this 10-minute sort of allowance for people to get their things and move out of their apartments anywhere? Does that happen anywhere else, as far as you know?
Honestly, Councilmember Gautier, I do not know how much time folks get in other counties.
Jacob?
So I would have the same answer that I don't know how much time people have in different jurisdictions, but I would also emphasize it's only 10 minutes if you're home when they come to lock you out. If you're out at work or you're out getting dialysis, you're at an appointment, you come home and you are locked out. You have 0 minutes to get anything.
Okay. It just seems incredibly inhumane. And like a practice we should outlaw right away. So thank you for that. And I was just wondering about what other people or other municipalities do. My second question is around this sort of writ by judgment. It also sounds like in many of the testimonies that this is being abused to get an eviction ruling with people not even being aware that the ruling happened. Is there some sort of fix we should also make to this process as it relates to how it happens in the courts that would help with this issue?
Thank you, council member. Mr. Spidell mentioned earlier the possibility of making the writs stale after a certain period, and that would go a long way towards preventing, disincentivizing landlords from serving writs prematurely. Right now, the practice is to seek a writ as soon as they are able, writ of possession, that is the first writ, so that they can move forward with a lockout as quickly as possible if they decide to get one. So putting a time limit on how long that first writ is valid would go a good way to making that less of a part of the practice.
Should there also be, and this is for, anyone on the panel who can answer, should there also be some kind of reform to the amount of judgments that are sort of placed on tenants because they did not show up at court for whatever reason, whether they could not make it to court or didn't have or were told by someone erroneously that they didn't have to go to court, that this also seems to be a part of what's happening here.
Yes, I think the problem of the high number of default judgments being issued is inextricably linked to the quality of service that's being provided in Philadelphia. There's one company in particular for which I have seen numerous outright false claims of service being made, personal service being made on people who are incarcerated at the time, people whose descriptions are wildly at odds with their actual appearance. Someone who's in their 70s being described as being 20. These are accepted without any second thought by the court. There is no scrutiny of affidavits of service, and the same people who sign those affidavits continue to make them every day.
So, go ahead.
I agree with that. Mr. Spidell highlighted that about the writs being able to be posted to doors. Affidavits of service or service can also be posted. And so we have received calls from people who said they have not known about the complaint, and it's because it was posted on a door that they don't use. I think the other reform here is after a default judgment is entered, there's a mailing that goes out, and that mailing is very nondescript and doesn't really explain what's going to happen. So it's easy for people to see that and not really understand what's going on.
Thank you. Are there any other questions or comments from members of the committee for this panel? Okay. There being none, Ms. Schroeds, will you please call the next panel to testify?
Kyle Webster, Leah Goodridge, Nikita Salehi Azan.
Kyle Webster, are you there and connected?
Yes, I am.
Can you please state your name for the record and proceed with your testimony?
Absolutely, and thank you. My name is Kyle Webster. I am the Vice President of Housing and General Counsel of Action Housing. Action Housing is the largest affordable housing nonprofit in Pennsylvania. While we do some work statewide, our footprint is primarily in the southwestern Pennsylvania region, with about 85% of our work in Allegheny County, where Pittsburgh sits, due to our being founded by R.K. Mellon and David Lawrence, two of Pittsburgh's most historically prominent business leaders and political leaders, respectively. Action Housing is a developer, program administrator, asset manager, and property manager. It is in this last category that we are sometimes the victors. As chief counsel for the organization, I have oversight over how we handle eviction processes and often lead the efforts myself. I think it's notable to say at this point, it appears I am the only landlord attorney that is testifying today. If that's helpful in any way, I'm happy to speak to that in addition to my expertise in Pittsburgh. I am also actively involved in housing stabilization and eviction prevention efforts and had the privilege of being one of 5 attorneys asked to sit on the working group convened by the Allegheny County Court of Common Pleas 5 years ago to establish our centralized housing court and redevelop our eviction process. I was asked to come here today to discuss how Allegheny County handles orders of possession. I am not an expert in Philadelphia's policies or procedures, and I have never been engaged in evictions of any sort in Philadelphia. So I cannot draw parallels, but can offer you what we do and hopefully allow you to make comparisons yourself based upon other testimony today. I want to start by being clear that an eviction, no matter how well executed, is a traumatizing and dehumanizing process for the tenant. It can similarly be traumatizing for the evictor, but in our current system where housing, even governmentally subsidized housing, is governed by the free market and capitalistic ideals, it is the only legal cure to breaches of the lease contract, most commonly through failure to pay. It is the only civil breach of contract claim in Pennsylvania where the standard and routine procedure for enforcement involves an armed individual showing up at the person's home and forcibly escorting them out with their belongings. Allegheny County is not perfect in how we handle evictions and lockouts. Mistakes are made, processes can be flawed, and inconsistencies exist in how things play out, often depending upon where you are in the county and or what judge you are in front of. Our process in Allegheny County is as follows. Once an order of possession is issued, the landlord makes payment to the court for execution of the order. At the magisterial district court level, this execution is handled by the constable, and if the matter has been appealed to the Court of Common Pleas, it is handled by the sheriff. The constable or sheriff will post on the door of the unit or the external locked entrance of the building in which the unit exists 10 days prior to the potential lockout. This allows the tenant to still pay and stay up until the date of the lockout. Best practice in the county requires proper notice to include the date and time of the anticipated lockout after the 10-day period passes. This does not always happen, but commonly does, especially in the districts that see the most evictions and the most lockouts. On the day of the lockout, the sheriff will arrive in full uniform, and the constable is permitted to arrive in plain clothes, but must have on them their clearly visible badge and must identify themselves. A representative for the landlord meets with the constable or sheriff, and the lockout begins with the knock on the door and a clear identification of who is present. There are also current conversations around offering or even requiring a mental health professional to assist in more complex lockout situations. While this is not currently the practice in Allegheny County, any conversation around making the process better and safer for all involved should consider this much needed policy addition. The tenant is then asked to leave the property voluntarily by the constable or sheriff, and the locks are then changed and belongings are removed. This scene can be chaotic and stressful for all involved, so our local policy mandates a clear understanding of who is present and what role they play to ensure it is as safe and orderly as possible. In that regard, the individual typically enforcing the lockout is the constable. The constables undergo extensive training and are held to the standards outlined in the Constable Handbook, which, as was referenced earlier, is a 77-page guidebook that clearly outlines expectations across the many tasks they are responsible for in the county, to include lockouts. Their mandatory training also includes, amongst other things, de-escalation and proper firearm handling training. Things like proper notice, clear announcement of who a public official is, and proper training are easy, obvious elements of a comprehensive local landlord-tenant policy. However, there are many more things that can and should be considered that I am happy to discuss and would welcome the opportunity to advise on. Evictions are easily my least favorite part of my job, even in the most justified situation. I know that I am causing an individual who has the right to housing to potentially face being unhoused. This action should not also imminently risk a tenant's ability to exist due to an improperly handled eviction. I am hopeful that landlord attorneys like myself continue to be brought to the table alongside policymakers and tenant advocates to create comprehensive and humane answers to the complex issues caused by the current reality of evictions. Thank you for the opportunity to speak on this matter.
Thank you so much for coming and sharing with us. As we know, evictions are always going to be traumatic, but it sounds like you all have a lot of model policies that we should be looking to implement here in Philadelphia. So thank you so much. Leah Goodridge, can you please state your name for the record and proceed with your testimony?
Hi, I'm Leah. Can you hear me? Okay, perfect. Thank you. So I'm Leah Goodridge. I'm from Mobilization for Justice. I'm testifying jointly with my colleague Nikita Salehi Azan. Nikita, are you here?
Yes, I'm here. Good morning, everyone.
Okay, perfect. So I'll tell you a little bit about Mobilization for Justice, which is the organization where we're from. Mobilization for Justice, we envision a society in which there is equal justice for all. With that in mind, we believe that a holistic approach is necessary to disrupt systemic injustices that exacerbate the problems created by poverty. So in sum, Nikita and I are both social justice movement lawyers, and we represent New York, one of New York's most vulnerable populations, low-income tenants at risk of eviction. A question we ask our clients, if evicted, where will you go, is often met with a dazed look that reveals the answer, nowhere. Evictions are violent in many ways. They are physically violent. Many evictions have resulted in death, as seen when a tenant died by gunfire in Seattle. And according to a recent report published by Dr. Russell Weaver at Cornell University, higher rates of eviction correlate with more crime. Evictions are also emotionally and mentally violent as well. As many people have testified from their personal experiences, that is also backed by data and research. Evictions cause depression and trauma, especially in children. I could go on and on and on, but I think that it's clear from the testimony thus far about the impact of evictions. So what Nikita and I want to do is compare, in essence, Philadelphia's eviction process to New York. We are in New York. And so we want to just also kind of frame the conversation by saying that our job is to prevent evictions. So we in no way, shape, or form are saying that New York's eviction process, or that there should be an eviction process, number one, but that New York's eviction process is perfect or something to be modeled. Our ideal is that there be no evictions entirely because they're just a violent process. However, that being said, we don't want for people to get harmed or die. And so we would like to provide a little bit about how New York's eviction process goes, the Marshall process, and just provide some insight into what things that tenant advocates have advocated for successfully to change to make the process better, and some pitfalls along the way. So I'll let Nikita go forward.
Hi, good morning, everyone. Thank you for that introduction, Leah. Good morning. My name is Nikita Salehi Azan. I am a housing attorney and tenant advocate at Mobilization Justice, Inc. In New York City. And as Leah stated, I'm going to be comparing and contrasting the different policies and procedures surrounding the lockout processes in Philadelphia and New York. Through this side-by-side analysis, I will be exposing the shortcomings that are inherently present in both processes, but are noticeably more prominent in Philadelphia and have attributed to the recent eviction-related crimes in the city. As a tenant advocate, I believe as some of the other panelists have mentioned, I also believe that any lockout system should be 1, publicly accountable with meaningful regulation, 2, transparent with clear public and written policies, 3, predictable, 4, involve rigorous and frequent training, and 5, be resource driven. So the lockout process should be integrated within the city's delivery of services for those who are displaced. Now, some of the specific differences that should be noted between the New York City and Philadelphia lockout processes include clear notice of eviction. So in Philadelphia, many tenants report that they don't even know that they had an eviction case filed against them, let alone that they lost a case by default, let alone that they will be locked out. By contrast, New York does require clear proof of eviction by conspicuous placement on the tenant's doorstep. I know that is not always followed through in a lawful manner, as many of our clients would contest, but that is our policy. With regards to window of lockout timing, in Philadelphia, the lockout often happens many months after the writ of possession is served, as some of the other panelists have explained, and tenants who do not have an attorney who can call the landlord-tenant office have no way of knowing when this will even be. Even when a tenant's attorney calls the landlord-tenant office, they often do not get any useful information about when the lockout will occur. Now, one of the biggest contrasts is in New York, the eviction can happen anytime in the next month while the warrant is still valid, and tenants and tenant advocates can call the city marshal that is assigned to them to see where their place is in the queue for the following day. This short notice that is available to the tenants has been shown to have no adverse impact on the city marshal's safety, as I want to stress. With respect to written guidelines, Philadelphia has no written policies of any sort for the landlord-tenant officers to follow or for tenants to refer to. Conversely, New York City has a 236-page Marshal's Handbook, which might not be very easy to find on the Department of Investigation, but is there, including clear policies about what to do if there are any children in the home, if there are any elderly or disabled people, etc. With regards to level of integration services such as APS, there is no coordination between services and lockout processes in Philadelphia. However, in New York City, we do have the policy stating that the city marshal must inform APS or other appropriate social welfare agencies providing assistance to the occupants at least 24 hours in advance of the new eviction date so that the social welfare agency may send a representative to meet the marshal at the eviction site to provide assistance to the occupants. So in conclusion, although New York City and Philadelphia's city marshal policies have many gaps and gray areas that arguably need improvement for a more accountable lockout process, as a tenant advocate, we believe that Philadelphia has more heavy lifting to do to ensure that the process is afforded to its citizens with safety, dignity, and transparency. Thank you.
Thank you so much. It's so valuable to hear you make that comparison in a very detailed way between what's happening in New York and what's happening in Philadelphia. And I agree with both of you that we should be trying to avoid evictions and prevent evictions, but to the extent that they have to happen, people should be treated humanely. It's not okay to treat people like they are disposable just because they don't own property or land. So thank you so much. And I look forward to incorporating a lot of these policies and how we move forward as a city. Councilmember Brooks.
Thank you so much, Chair Gautier. And thank you, Leah and Nikita, for sharing how you guys are doing it, right? And how we can get better. And there are some lessons learned. So I just want to thank you for that. But my question is for Mr. Webster. As a landlord, how do you view the regulations and transparency that are baked into Allegheny County's eviction process?
It is helpful. I will say it's not perfect. The best practice is to name a date and time. Often we'll find that the constable can be late. The constable can sometimes even call us at they'll say 10 a.m. on Tuesday, and then 3 o'clock rolls around and they call us and say, actually, I'm not going to get to it till tomorrow, which we can work with, but it does mean that we have a staff member who is there all day waiting for the constable, which can be a drain on our resources of trying to do other things around housing. Evictions is not our primary thing. It's providing housing. So it's not perfect. I will be honest, it sounds like in Philadelphia, the landlord doesn't have to meet the person for the lockout, which seems odd because the locks are generally changed and the landlord is who would initiate that happening. So that is a little confusing to me. But it would also, I just couldn't imagine dealing with that scenario. Honestly, we need to know when we're supposed to be there because we need to be a part of that lockout. That's part of landlord accountability. And also, obviously, we want to ensure that the property is maintained in the lockout as best as possible. The timing also has made it so that we have had the privilege of being able to contact family and friends of a tenant if there's a unique mental health crisis or other issue that we're concerned about to try to ensure that they can be present to assist. So I think it is a much more advantageous thing to be able to have at least a ballpark of when the timing is. The most it's ever delayed is generally 24 to 48 hours notice, though that's rare. It also does sound like you all incentivize overpacking your schedule for the landlord-tenant officer. That's not how it works with the constable, which I think is also advantageous. So we've had the constable sometimes where there is a clear mental health crisis, where the constable will hang out with us for a couple of hours as we try to make sure that the tenant safety is achieved in the context of the lockout. And, if we have to engage mental health experts, if we have to do a resolve crisis situation, et cetera, the constable will gladly stay and see the eviction to its conclusion, regardless of what length of time it takes.
Thank you so much, Mr. Webster, for sharing how it's done in Allegheny County and, and kind of shedding the light on how we definitely need to improve the way services are delivered here in Philadelphia. Madam Chair, that's the end of my questions.
If I may, sorry.
Go ahead.
I just wanted to briefly also add, New York's process with marshals has evolved over time after a series of unfortunate incidents. So for example, two of the more notable ones are where two Black women died separately. One many years ago, Eleanor Bumpers, who was in New York City Housing, the Housing Authority, our public housing agency, and a second, Deborah Danner, which was in 2016, and both of them had mental health issues. And so it's so critically important that during these processes, there are resources because evictions are violent, and even people without struggling with mental health processes will react very differently. And so what many tenant advocates have fought for is for in these processes to have there to be the adult protective services for people who are well advised and well trained in dealing with people who are going through a mental health crisis, and also clearly who won't further bias, right? Because these are Black women, and it was pretty clear, at least from the tenant perspective, the tenant advocacy perspective, that perhaps the violence would not have been the same if the tenant had mental health crises, but were, for example, white. And so these are all the things that tenant advocates and the tenant movement have fought for, to have, first of all, to have no evictions, but if we were to, then at least to provide resources for folks to be better trained to do so. And I just want to end by thanking Councilmember Brooks for inviting us here. We really appreciate it, for reaching out to have our perspective. We really appreciate it. Thank you.
You're quite welcome.
Can you clarify, did you say that the mental health professional currently is sort of a part of the process?
Yeah, if there's a tenant, part of the New York City eviction process, which again came as a result of tenant advocates pushing for this, is if there's a tenant and there is awareness that they have mental health issues, then what's called APS, the Adult Protective Services, will get involved. We call them and they will get involved. That means that they will be part of the eviction process. And again, these agencies are not perfect. So, anyone listening to us in New York, none of these agencies are perfect that I've mentioned, but I guess, what I'm saying is these are at least the bare minimum to think about.
Okay, and so that's if a tenant, if someone.
The physical or mental health, actually, because we've actually had a lot of tenants who they are literally they're scheduled to get evicted. They physically are disabled, and they're like, where am I going to move all of my furniture to? I can't go anywhere. I'm homebound. And so the Adult Protective Services will enter for those issues as well. So basically to prevent ableism in the eviction process.
And who makes that assessment on whether a tenant would need mental help with mental health during an eviction?
A few players. One is the tenant will have gone through court, and sometimes when they're interacting in court with either the court attorney or the court personnel or the judge, they might make that assessment. If the tenant has an attorney or has met with an attorney to represent them, that attorney or advocate or paralegal might make that assessment and call APS, and then APS will take it from there. Which again, they're not, when it's stressed, they're not perfect, but it is something at least to think about, for evictions, because it's otherwise then you have folks who do have disabilities, and there's a higher, we don't want a higher likelihood of them being harmed or even worse, killed.
Okay, thank you. And I have a question for Mr. Webster. From a landlord's perspective, do you think that there are benefits to landlords that are derived from having a process that is transparent, more transparent, and more humane for tenants as compared to what you've heard in Philadelphia? And how would you describe those benefits, if so?
Yeah, absolutely. And I want to give the same disclaimer that Leah gave. Pittsburgh is not perfect. It is far from perfect. A lot of people that I work with would cringe to know that I was testifying in favor of our process. That being said, from a landlord perspective, I mean, landlords care predominantly about, money, profits, etc. From an efficiency standpoint, having a predictable process is more efficient and therefore generates less staff time, generates less overhead on our part. Being candid, when we talk about mental health crises or other issues, a tenant who is forcibly removed has the potential to cause substantial damage to our property, has the risk of putting our staff at potential harm. And so having a predictable process that also integrates mental health resources can also protect our property. It can protect our staff. It can ensure that, it is an advantageous process for everyone as best as possible, given how problematic the process is, in a baseline. So yes, I do think that there are substantial benefits. It protects the property, it protects the individuals, and it also just allows for better and more predictable planning.
Thank you so much. Are there additional questions or comments from the members of the committee for this panel? Okay, there being none, Ms. Strolls, will you please call the next panel to testify?
Andre Del Valle and Mark Zucker.
Andre Del Valle, are you there and connected?
I am. Good morning, council member.
Good morning. Please state your name for the record and proceed with your testimony.
Sure. Good morning, Councilmember Gaultier and members of the Housing, Neighborhood Development, and the Homeless Committee. My name is Andre Del Valle. I'm the Vice President of Government Affairs for the Pennsylvania Apartment Association, representing just under 285,000 units and 300 property management companies across the Commonwealth. Locally here in Philadelphia, we represent over 38,000 units and 49 property management companies. I'd like to thank the resolution sponsor, Councilmember Kendra Brooks, and her team for their willingness to engage with our association and for having an open dialogue on the resolution before you today. We greatly appreciate the opportunity to testify today and look forward to cross-collaborating. It should be known that our apartment owners and managers do not seek out opportunities to evict residents, which is why the Pennsylvania Apartment Association proactively worked on policies like the nationally recognized eviction diversion program here in Philadelphia, and even joined the White House Eviction Reform Summit as we all work to prevent housing instability across the Commonwealth and our country. Many of our members prior to and during the pandemic proactively met with residents who were facing financial hardships and began creating, and to this day continue to make, payment plan agreements. And once the American Rescue Plan funds were made available, those very same housing providers urged tenants to apply for these funds made available by President Biden's administration. These emergency rental funds assisted landlords who had not received payments in over 2 years, while also assisting tenants by ensuring their arrears were paid off. Last budget cycle, we advocated alongside several city departments and groups like Community Legal Services and the Philadelphia Bar Association for local rental assistance funds to be made available, and we're successful in getting $45 million in local rental assistance, which benefits both tenants and housing providers to prevent housing instability across the city of Philadelphia. As we know, the eviction process is both costly and protracted, and there's no economic incentive for these owners and managers to file for an eviction, except as in a last resort when a lease or contract is breached. It's simply bad business to have vacant units or high rates of evictions in our buildings and industry, which is why nationally we're running at a 96 to 98% occupancy rate among our multifamily housing industry. Evictions are often sought in cases of non-payment of rent, instances when a resident is jeopardizing the safety of others, or disrupting other residents through nuisance behavior. Today's hearing examines the specific issue of evictions and the role of the landlord-tenant officer. And let me be clear, evictions are a troubling experience for all parties involved. However, they are a necessary part of managing an apartment community. Rental housing providers engage in the eviction process as their only legal remedy to remove a resident who has breached the lease and lawfully regained possession of their property. Here in Philadelphia, evictions occur after a housing provider has already tried to negotiate with the resident and now legally must go through 30 days of mediation with third-party mediators through the eviction diversion program, trying to find common ground to prevent an eviction. There are notices sent for mediation, notice of rights, writs, and a number of other outreach pieces to the resident, all prior to an eviction being carried out. Now, we're not here to speak on behalf of the landlord-tenant officers, the courts, the firms. However, I can say that many housing suppliers across the city do rely on the landlord-tenant officers who are not sworn enforcement officers. And unlike other Pennsylvania jurisdictions, as mentioned before, the courts allow a private attorney appointed by the president judge, known as a landlord-tenant officer, to enforce the eviction order stemming from these cases. This is due to expedited processes, reduced costs in comparison to city departments. While other counties have sheriffs, deputies, or constables who perform evictions and serve orders in these cases, Philadelphia primarily relies on these landlord-tenant officers or the sheriff's department. Many housing providers across the city of Philadelphia have shared several concerns about the potential increased costs, process delays, and other challenges of the eviction if the process on the eviction process if the intent was to transfer this process through the sheriff's department due to staffing shortages. Obviously, based on today's hearing, there are growing concerns with the landlord-tenant officers and their current process, as you've heard from previous speakers. The Pennsylvania Apartment Association welcomes any opportunity to continue to work with this committee and all stakeholders who would be impacted by any potential changes to the existing structure, whether that is local with Councilmember Brooks and yourself, Chair Member, as well at the state level with my state senator, Nikhil Saval, or Senator Street, who have also expressed concerns. Today's and what I hope will be future conversations does not have to be an either or, but rather an and conversation on how we can all work with housing suppliers and find innovative solutions within the current infrastructure, all while protecting the residents across the city of Philadelphia, a goal we all share. We do believe there are tangible solutions that do not add further cumbersome requirements to the landlord-tenant officers, the courts, or that would increase the cost on housing suppliers who in the end need to go through an eviction process, all while also protecting residents. We appreciate the opportunity to testify today and look forward to working with this committee to find in the future to find innovative solutions.
Thank you, Andre. We appreciate you being here today, and we appreciate your partnership on initiatives like eviction diversion, and look forward to partnership on this process as well, and making it better and more humane for people. Mark Zucker, please state your name for the record and proceed with your testimony.
Thank you, Chair Gaudier and Councilperson Brooks. I am Mark Zucker, as you noted, and as Chancellor of the Philadelphia Bar Association, I express the association's gratitude for the opportunity to participate in today's hearing. As you know, our association was founded in 1802 and is America's first chartered metropolitan bar association and Pennsylvania's largest local bar association. Our mission is to serve the legal profession and the public by promoting justice, professional excellence, and respect for the rule of law. In so doing, the association strives to foster understanding of, involvement in, and access to the justice system. And it is in that context that we served as convener of the stakeholders relating to this dispute. As you no doubt are aware, until 1970, the service of writs of possession and the implementation of lockouts in Philadelphia eviction cases were performed by constables under a uniform system applicable to counties throughout the Commonwealth. That changed as of February 10th, 1970, when the office of constable was abolished in Philadelphia. Since 1970, as authorized by statute, the president judge of the Philadelphia Municipal Court has contracted, as you've said, with a private entity known as the Landlord-Tenant Office to serve writs of possession and perform lockouts in eviction cases. Also by statute, the president judge of the Philadelphia Municipal Court has the authority to appoint and remove landlord-tenant officers and writ servers. While concerns about the Landlord-Tenant Office entered the public consciousness as a result of the shooting of Angel Davis on March 29, 2023, these issues have been a focus within the public interest community for years. The operation of the Landlord-Tenant Office is of paramount concern to members of our association and has occupied a significant amount of our time as we seek to ensure that all stakeholders' voices are heard. As you know, our association includes judges, as well as attorneys and other legal professionals. Those attorneys include counsel to tenants, landlords, public interest entities, and counsel to the landlord-tenant officer herself. The procedures and protocols followed by municipal court and by those entrusted with carrying out evictions and lockouts has been the subject of prior resolutions of our association, including one in May of 2019, as well as several meetings between the judiciary and our Access to Justice Task Force, our other sections and committees, as well as legal services organizations. It is an ongoing process and one which we take very seriously. Most recently, after a resolution for consideration by our Board of Governors was drafted in the wake of the Angel Davis incident, our various sections and committees convened meetings with members voicing a multiplicity of perspectives to address that resolution. These meetings were intense and they were heated. Rather than simply proceeding with debate on the resolution, we chose a different path, with the goal of achieving meaningful progress and minimizing acrimony. We invited President Judge Dugan, Landlord-Tenant Officer Marissa Shooter, and representatives of landlords and tenants to speak at our board meeting on April 27th, 2023. Through initial discussions prior to the board meeting and presentations at the board meeting, it became apparent that our efforts were best directed at bringing all stakeholders to the table to address areas of common ground and potential reform of current procedures and protocols. In particular, we chose to be forward-looking and to focus on the categories of transparency, accountability, and training, rather than sorting through the facts surrounding the shooting of Angel Davis, which itself is the subject of ongoing investigation and litigation. As a result of our board meeting, the president judge agreed to convene a meeting of all stakeholders, and that meeting occurred on May 23rd of this year. At that meeting, each participant aired their respective concerns. President Judge Dugan asked Supervising Judge Wolf to continue these discussions. Judge Wolf, in turn, convened a meeting on May 31st of this year and announced an intention to continue those discussions in conjunction with a Pew grant dedicated to promoting reforms in the municipal court. We are heartened by these developments and fully support the court's initiative in seeking ways to maximize the three aforementioned goals of transparency, accountability, and training. Included within those goals is the necessity of written protocols that would guide the hiring, supervision, and training of deputy landlord-tenant officers in the field, and likewise provide opportunities for de-escalation and guidance to those seeking to hold the landlord-tenant officer or office accountable for its actions. Along the way, our hope is that additional resources can be allocated for access to social services, homeless services, and mediation in order to avoid disruptive displacement and provide alternate pathways for those caught in the eviction process. We have every expectation that the stakeholders are motivated to move forward constructively, and we stand ready to assist them in this process. Our hope is that meaningful progress can be achieved in the next several months. Likewise, we hope to partner with City Council to act as a resource in advancing the common goal of a fair, safe, and effective system in which landlord-tenant issues can be addressed. Thank you again for this opportunity. I would be most grateful to answer any questions you may have.
Thank you so much for being here today, and thank you for your role in acting as a facilitator and a convener for these important conversations. It was also good to hear you speak broadly about sort of the topic areas that you would want to see the stakeholders focus on. But I did want to ask if you, based on your participation in these conversations, do you have any specific reforms that you would suggest or recommend?
I'd rather not get into specifics for a few reasons. One, the resolution is still out there, and I want to leave open the opportunity for members of our board to drill down on those. And secondly, we're convinced by the sincerity of Judge Wolf's approach to this, that he will be looking not only at the suggestions of those around the table, but also the best practices that have been alluded to in some of the testimony today. And so we don't want to limit the reforms to what we might imagine without looking at those best practices.
Okay, that's fair. Thank you. And again, thank you for your role in this work. I have the same question for Andre. Based on, what you've seen through your membership base and the testimony that you've heard today, both from tenants and legal service professionals, particularly from other places that have described how evictions work out, in places other than Philadelphia. Do you have thoughts on how this process should be reformed or changed?
Yeah, and I appreciate the question, council member. I would echo similar sentiments to Mark here. Because we do rely heavily on both the sheriff's department and the landlord tenant officers, I wouldn't want to misspeak or add our perspective on a process that is handled by a firm. I would say, if we're truly committed to this process, which obviously, us testifying today, we are, we would just encourage, the opportunity to bring all the stakeholders together, including landlord tenant officers, the courts, to really figure out what these best practices are. And what I will say is we're committed to looking at other areas because we are a statewide association. We will be happy to look at other areas and come back with some of those best practices, but I wouldn't want to, speak on behalf of the courts or any other groups here today.
Okay, thank you. Are there additional questions or comments for this panel from other members of the committee?
Chair Gautier, I just wanted to thank the panel for coming to participate in this hearing, and I really am hopeful that some of the takeaways will be taken in consideration towards future planning about the eviction process here in Philadelphia and reform to the landlord-tenant court. I mean, I was really pleased to hear some of the things that we're doing in other parts of the Commonwealth, as well as things that they're doing in New York. And I would love for our process to mirror that and even better, because we talk about housing as a human right. And I do realize that, here in Philadelphia, we have worked closely on various tenants' rights issues with Andre Deval and his organization. And I would love for this process to continue to move forward so we don't have another incident like what happened to Angel Davis and the other unspoken incidents that may have been unreported. So thank you for being willing to show up to this hearing today. And I look forward to working very closely with you both on implementing some real changes.
Thank you so much. That concludes panel testimony for this resolution. Ms. Sherles, do we have anybody registered to provide public comment?
Yes.
We will now take a brief break to connect those individuals who have registered to provide public comment to the hearing.
Hey, Madam Chair, we do not need a break. Actually, we can call them in as soon as possible.
Okay, great. Thank you. Ms. Sherles, will you please read the name of the first person registered for public comment?
Asantewa Nkrumah Ture.
Asantewa.
Hello?
Hi, can you please state your name for the record and proceed with your testimony?
This is Miss Rosa King. This is not Asantewa.
Okay. Is Asantewa Nkrumah Ture here with us?
No, she has a different number. I can give you her number.
Council support, do we need to do something to get Asantewa on for public comment?
Yeah.
Miss Rosa King is also signed up for comment.
I understand. I'm just trying to make sure that we go through our list and, that everyone who wanted to be heard is heard. So just 1 second, please.
All right.
Council support, do we have to do anything to get Asantewa on?
Yeah.
I gotta go to work, HT.
We can get Asantewa in. It's our list within a different order than so. We'll call Asantewa in there.
I wish they would just take me.
Darian, are you there?
Yes. Can you hear me?
Yes. Do we need to do anything to get Asantewa on for public comment?
Yes, we can call Asantewa in now. It's just our list was in a different order, so it had Rosa at the top, so we was going in order. Sorry.
Okay. Well, we'll move on to Rosa while you do that. Okay. Rosa King, can you please state your name for the record and proceed with your testimony?
Okay, go ahead. Hello.
Hello, we can hear you. Please state your name for the record and proceed with your testimony.
Okay, my name is Rosa King,
And I understand y'all talking about the evictions. I've been evicted 5 times in the city of Philadelphia, and neither one of them, none of the evictions were legal evictions because they were all slum landlords. I should have never been put in landlord-tenant court. And one particular landlord did an illegal eviction, locked out and confiscated all me and my children's belongings. I also experienced having been put out by the sheriff's department. You know, they came and put us out in the street in front of all our neighbors. So, you know, I'm a little bit confused why I got evicted by landlord tenant court anyway, because the law says that landlords are not able to put out people when their houses are in substandard conditions. And all those properties that I was allowed by landlord tenant court to have to leave were all in substandard conditions. Okay? All of them. And my name is in the system, landlord tenant court, and they refuse to let my name go. They put mud on my name. I want my name out of there. And I want to make a comment on Angel Davis. She should have never got shot in the head. In instances like hers, she should be compensated financially by landlord tenant court or her landlord and the sheriff that put her in that position. She should be made whole again. I feel as though I should be made whole because all this led me up to mental health housing I'm in now, which I wouldn't have been if the laws were handled properly for a tenant like myself and herself. So I believe in people being held accountable.
Thank you so much
Yes,
for.
ma'am. You're
Sorry, were you finished or not? I didn't mean to
That's
cut you
it.
off.
I just want to see some accountability held, even if we have to go back in time, you know, and restore me and restore Angel and make us whole, even if that's financial compensation.
Thank you so much. Really sorry to hear about your experience, but also really appreciate you coming here to share your story and to speak up so that we can make some important changes to the system.
Okay, I do appreciate sympathy, but I would appreciate even more laws being followed.
I understand. Thank you for
So
being
that
here.
you won't have to have sympathy for me and other people won't have to have sympathy. Just follow the laws. Okay? And tenants like me will not suffer. Have a good day. God bless you. Jesus loves y'all. Take care.
Thank you, Ms. King.
Bye.
Is Lizzie Shackney there and connected?
We're calling her in currently.
Okay. Can you let me know when we have them and when we have Asantewa on?
Hello, this is Lizzie.
Hello. Thank you for joining us. Can you please state your name for the record and proceed with your testimony or proceed with your comment?
Yes. This is Lizzie Shackney. And I should begin?
Yes, please.
Okay. I'm speaking today as a housing justice organizer, a law student, and a Philadelphian. It was my involvement in organizing work in Philly that led me to sit by Angel Davis's side in the days and weeks following the shooting, bearing witness to her trauma. She experienced and I observed the chaos of trying to seek a safe space to recover after such a horrible act of injustice. The people who stepped up to enroll her in public benefits, to try to stabilize her life, to raise funds to support her, find new, safe, certain housing, they weren't professionals, they were just everyday people. There was beauty in that, but it was also terrifying. Where were the resources? And once we could identify them, why were they so hard to integrate? How could we ever expect someone who suffered such a trauma to navigate so many different bureaucracies? I distinctly remember calling her council member and being told there was nothing they could do to help. I was reminded in an intimate and urgent way how difficult it is to find deeply affordable quality housing and how nearly impossible that is after a person has been shot in the head during the epitome of a violent eviction. It's hard for me to comment on reforms to the LTO because it's the tip of the iceberg of all that is immoral and wrong about how we approach housing in this city and in this country. The appearance of corruption, the profit motive, the lack of training and transparency, the unpredictability of the process, the fact that officers arrive in plain clothes, it seems so abundantly clear that the system must go. Councilmember Brooks prefaced her comments by saying if an eviction must be done, and I think that's an important place to begin. We know these systems go hand in hand. A recent study out from the Eviction Lab just last week showed that the cheaper it is to carry out an eviction, the higher the risk of eviction in a jurisdiction. I wish that our time and resources could be spent on all that comes before the violent removal of a person and their family from their home. But so long as evictions are part of our reality and so long as a deputized private security officer is carrying them out, I urge council and the state and the courts to take action to ensure the safety, transparency, and accountability of this process. Thank you.
Thank you so much for giving comment today and for speaking up for Angel Davis. We really appreciate you. Is Asantewa on the line at this point?
Calling her now.
In Chroma Ture.
Hi.
Hello.
Hello,
Hello.
Asantewa. Can you hear us?
I can hear somebody. Is this the hearing?
Yes, this is Councilmember Gaudier.
Okay. Hi. Good morning. I've been waiting for someone to call me to get on per their instructions.
You're on. You're live. Please state your name
I'm
for the
sorry.
record. No, it's okay.
Okay.
Please state your name for the
All
record
right.
and proceed with your comment.
Certainly. Thank you. Well, good morning, everyone. My name is Asantewa Nkrumah Ture. The only pronoun I am using today is Housing Justice Community Organizer. I'm a member of the Justice for Angel Davis Now campaign, and I want to thank Council Members Gautier and Brooks and all your colleagues for this hearing this morning. As we all know, on March 29th, Angel Davis was shot twice in the head, and only by the grace of God and the ancestors, she is still alive. While Angel Davis could not be with us here today, she sends her thanks to everyone for their support. So, if I may, for the Justice for Angel Davis campaign, we have several demands. One of which is the total end of the deadly LTO system, period. Hold Marissa Shooter, the LTO officer, and her husband, Municipal Judge David Shooter, accountable, because what we have now amounts to a mercenary army for landlords. We must also compensate Angel Davis, her partner Gabriel Plummer, and all tenants that have been unjustly and perhaps illegally evicted. We must also hold slumlord Odin Properties accountable. They did not have a license until March 31st, 2 days after Angel Davis was shot. They are notorious in other states, and here in Philadelphia, they have a large number of evictions. They have a large number of code violations, and it should also be noted that Odin Properties made campaign donations to several candidates in our recent Democratic Party primary. Also, as a demand, license and inspections, our city agency must have all the resources necessary to do inspections and make sure buildings are safe. Now, with this campaign, this is a grassroots campaign, right? We're just regular folks. So I also want to give special thanks to all the organizations that are part of this campaign. They include the Philadelphia Rent Control Coalition, DSA, PSL, YCL, PTU, and especially CARP, who quickly organized the GoFundMe to make sure Angel Davis had immediate housing, food, transportation, and other necessities. We as community organizers did all of this while no agency of the city of Philadelphia stepped up. And that's a shame for the city of Philadelphia. Additionally, there are other issues. So for example, there are also, as some of you may know, additionally, there are also numerous incidents of violent and or illegal evictions where landlords or their proxies carry out evictions without going to court. The Philadelphia Police Department must be trained and take seriously what is and is not a legal eviction. As some of you may recall what happened to me last year when the new owner of the house I lived in at the time violently and illegally tried to evict me, and I was under siege for 10 days. Friends of mine, some of who are watching this hearing, stayed with me for 24 hours a day for 10 days from February the 6th to February 16th to make sure I was safe. If tenants have a record of evictions and judgments against them, then it's only fair that there also be a record of bad, violent, or otherwise unfair landlords. This must happen as well to make sure this is fair and to make sure tenants who go through this horrendous process can be able to afford housing in the future. Now, I've been going to a lot of events and passing out flyers. We've been sending thousands of emails, everybody, everywhere, across this city and across this country. We have partners across this country who are also willing to join with us in this campaign to put pressure on folks to do their job, do the right thing, and make sure there is justice for Angel Davis. But one thing that I keep getting from passing out flyers at Adun Day, at Juneteenth, and everything else, how is Angel Davis doing? Because no one has heard anything. Why is there no news coverage about this? Where is the body cam and who shot her? Why hasn't this LTO mercenary been identified? Is this situation being investigated, and by who? Is it being investigated by the police department, the DA's office, the FBI? Who is investigating this thing? And how do we get justice for Angel Davis to make sure this happens to no one else ever again? This is so wrong. And forgive me, but I'm emotional. Because some of you on here know folks threatened me with a gun last year. I have made repeated calls to the police, the DA's office, and they don't tell me what I need to know. Where are charges going to be filed against the people who did this to me last year? Because we sent pictures and video and all kind of evidence. Has the statute of limitations ran out for what happened to me last year? I call repeatedly all kind of police officers, send them emails, and no one will tell me those things. How will these people be held accountable? And what is the statute of limitations? When does it run out? So thank you all for listening. But first and foremost, Angel Davis, thanks you for your support. And we must end the LTO system. Tenant lives matter. Justice for Angel Davis now. Justice for Angel Davis now. Thank you so much.
Thank you, Asantewaa. We appreciate you being here to speak up for Angel Davis, but also to share your story. I'm also, I regret that the city has not gotten back to you on the status of your own case. As you know, we followed up not too long ago with the 18th District, who pledged to help us with Southwest detectives, and we'll keep pushing on it. But I appreciate you being here. Thank you so much. Are there other comments from members of the committee or questions? There being no further questions from members of the committee and no other witnesses to testify, I will ask if there's anyone else present in this hearing whose name we have failed to call and that wishes to offer testimony on the resolution being considered today. Hearing none, this concludes the business before the Committee on Housing, Neighborhood Development, and the Homeless today. Thank you all for your attendance, and thank you so much, Councilmember Brooks, for putting this very important conversation in place. And I look forward to working with you and all of the stakeholders and tenants to bring about some real change.
Thank you. Have a great day.
Bye-bye.
Thank you, Madam Chair.
Thank you.
That's the one where